Hi, it's Kiffin Lobates here, and you may have guessed from the thumbnail for this video, if you actually saw it, that today's topic is going to be the Moonbirds NFT project and the Creative Commons Zero license. And the reason why I can create a thumbnail full of Moonbird pictures, those pixelated owls that you may have seen, is because as of August 4th, 2022, the Moonbird's intellectual property, those pictures, are now under Creative Commons Zero license, which means that anybody can reproduce them and use them for personal or even commercial purposes. And this has annoyed a bunch of the original Moonbird NFT owners, because suddenly the exclusive right that they had to exploit Moonbird images associated with their NFT is gone. The analogy here is that what the token owners did was buy a lifetime ticket to a particular ride in an amusement park, only to wake up one day and find that the owner of the amusement park has decided that actually anybody can go on any of the rides for free. You don't need one of these tickets at all. And as a result, the NFT owners must be wondering to themselves, well, why did I shell out $30,000 or $50,000 on this thing now that it has no purpose whatsoever? So that's what I want to look at today. And I think the issues here are twofold. The first is that the general public does not understand copyright legislation, and nor should they have to really. And the reason is that copyright legislation is actually surprisingly tricky. Because what you're doing is you're legislating for the ownership of something that doesn't exist other than in the minds of human beings. And as a result, copyright legislation has evolved over the last few centuries. And the second problem is that NFTs have created a new space of ownership, and lawyers are trying to adapt boilerplate contracts that apply to traditional intellectual property to this new form of property, with, on the whole, pretty disastrous results. Those of you who follow me on LinkedIn may have read an article I wrote recently about how the Bored Apes Yacht Club has managed to snarl up their intellectual property terms and conditions, and I kind of feel that Moonbirds have done the same here. But anyway, back to the Moonbirds. So because the Moonbirds images are now under Creative Commons Zero, that means that they are effectively in the public domain. They have become images that anybody can use for whatever purpose they like. And the problem here is that there's a disconnect between what NFT owners think they're getting when they buy an NFT and what is actually currently possible under the standard contracts that are out there for copyright. So what NFT project owners typically do is they hold on to the copyright to the underlying art, and then they create an automatic license assigned to the owner of an NFT at the point that the NFT is bought by that owner. And the reason why you license rather than give the copyright to the underlying art to the NFT holder is you need to have a mechanism to transfer it from owner to owner to owner as the NFT is transferred. And there's no simple way of doing that at the moment under current legislative frameworks. You'd need to draft a pretty complex contract in order to achieve that, and nobody's paid the money to look into that and actually do it. Whereas from the NFT owner's perspective, because they don't understand copyright law, they have a gut feeling as to what it is that they are obtaining when they buy the NFT. And the feeling they have is, before I owned the NFT, I wasn't allowed to do anything with the image of an owl. Now I've bought the NFT, now I should be able to do what I like with that image of the owl, whether it be to look at it in the privacy of my own home and enjoy it. I find it funny how they talk about enjoying property rights, but that's the phrase that they use. And if I want to, I should be able to go out and produce 100,000 t-shirts and promote my owl and maybe make a profit off selling those t-shirts, or produce a game or a cartoon series or something like that, a pop music video, whatever you can think of. However, on the day that I decide to sell on my NFT, I should lose the right to do all those things, and that right should transfer over to the next NFT owner. So that, I think, is the gut feel that owners of NFTs have when it comes to what owning an NFT and the underlying art should be all about. Now, as is always the case with law, what you get is some edge cases that become a bit tricky. So, for example, what do you think of the situation where somebody bought an NFT that actually had a license that covered this particular concept, then printed off 10 million t-shirts in the space of a few days, and then sold the NFT on? Should they still be allowed to sell those t-shirts or not? And typically what is done here is that a limit is put on how much profit you can make off the assets after you've sold on the NFT. But again, it starts getting really, really complicated, and the project creators for NFTs, as I said, haven't really thought this stuff through. I've tried to deal with it with the terms and conditions of my own NFT project, the Authorverse. And what me and Richard did there is we said, well, the pixelated images of the land all look pretty much the same, so we'll just put those in the public domain, or rather license them under Creative Commons. However, the crests for the individual lands, those are unique and distinct. So we'll grant an exclusive sole license to each NFT holder for the crest alone, that they automatically lose when they transfer on the NFT, and that is transferred to the new owner when they buy an NFT. But my contract is by no means perfect. I'm not a lawyer. I just looked at the mistakes that I saw in the existing contracts and tried to adjust them. And to be honest, the feeling I got was that there isn't really a framework at the moment to cover this kind of concept. So, as I did in the article about the Bored Ape Yachts Club terms and conditions, I'm again going to lay out a challenge to lawyers out there. Start looking at this and see if you can come up with a template that actually covers the use case for the users. And that's the key thing. And it's a thing that we're aware of in the software industry, which is you're supposed to go and look at the experience from the user's perspective and build the software with that in mind. Now, often this isn't done, and it usually results in very bad software that has to be so functionally good that the fact that it's almost unusable is overcome. And that's the situation I think we're in with NFTs too, which is that the usability hasn't been considered. So that's the challenge. Go and look at what it is that users expect when they buy NFTs, build a contract based around that, rather than just going with the existing standard way that copyright licenses are handled, because it messes up. The NFT world is much more fluid and liquid. People are transferring these things much more often than is usually the case with copyright in the traditional world. In fact, that's really the problem, isn't it? People don't flip copyright ownership on a sometimes daily basis, but in the NFT world, that is precisely what is happening. Anyway, I've rambled on for far too long. This is an incredibly complex area, and I hope we get it sorted out sometime soon, preferably in my lifetime. And I'll see you all in the next video soon. Bye for now.